I would also note, however, that I do hope to share some views with you that would encourage you to consider partnering with me. We have a long road ahead in the context of this notion of this thing called fintech. And I am hopeful that through the development of legislative and regulatory initiatives, that we can identify some common goals, and that your learning and thinking and experience and data, information and research will come to inform the CFTC's mission, which is to offer robust investor protections and to foster well-ordered, financially sound markets that preserve market integrity, promote market stability, and avoid systemic risks. Taking a step back from that sort of macro view of the CFTC's mission, it's important to consider the impetus and salience of regulation. In the summer of 2021, following a church service, an older African-American woman approached me. She asked if I would share with her advice about which cryptocurrencies she should buy. I had not been sworn in as a regulator, I hadn't actually even been nominated, but I was wise enough to know better than to offer crypto investment advice to this older woman who's a retiree likely. She explained that she was interested in purchasing cryptocurrencies and wanted help choosing which she should include in her investment portfolio. For many months following that conversation with a smart, curious, enthusiastic would-be crypto investor, my thoughts and concerns ran the gamut. On the one hand, responsible innovation created through open, transparent, efficient, effective, competitive markets involving the development of distributed digital ledger technology may offer a number of benefits for a diversity of stakeholders in our markets. On the other hand, in a market with limited regulation, the illustrations of the recent crypto winter are all too common. Hard-working retail market participants who could often be low-income investors who may have used credit cards to withdraw cash to purchase cryptocurrencies, and even educated professionals with significant disposable income. And even beyond that group, professional investors that are largely almost exclusively engaged in digital asset markets lost their shirts. Before we start to think about what regulation could best serve this market, it may be useful to spend some time defining digital assets. I suggest defining in quotations because we are working on the epistemological common understanding of so many terms in the crypto universe that we would be a bit presumptuous to suggest that in the next few minutes I could define all relevant terms that relate to digital assets. But there are reasons to pause here and be careful. For a number of years prior to the conversation I had with the wonderful retiree regarding her investment portfolio, I began to explore, as Sanjay mentioned, the contours of the distributed digital ledger technology. I focused on envisioning a form of regulation for this new ecosystem that would at once allow it both to flourish, but contemporaneously ensure the kinds of protections we've historically afforded investors in our markets. I studied the attributes of this new class of assets and its potential for good, as well as the possibility that some might take advantage and exploit the novelty of the underlying technology to engage in egregious behavior, exploiting, misrepresenting, and abusing the faith and trust of unwitting, vulnerable, and all too often marginalized investors. What did my early studies reveal? Simply stated, digital assets defy the rigid, siloed designations that characterize financial market products in TradFi and that are characteristically described in financial markets regulation. In other words, digital assets resist neatly fitting into the designated buckets created for financial products. Distributed digital ledger protocols enable developers to create multifaceted entities and products that may play many roles. The distinctive attributes of these technologies do not, however, remove them from regulators' purview. Rather, it makes plain the need to adopt and adapt existing regulations, which are, by their nature, dynamic, to ensure that we introduce and implement effective, well-tailored regulation. It may be useful for me to offer an example or two of what I'm thoughtful about. Let's begin at the beginning in terms of federal regulation governing securities, commodities, and derivatives markets. In the early 1900s, federal intervention in financial market had been quite limited. The stock market crash of 1929 spurred the launch of a series of Senate hearings known as the Pecora hearings. During these hearings, senators listened carefully as investors detailed snake oil schemes carefully designed by professional thieves to part them with their money. Even though there were existing state regulations and state attorneys general had rigorously enforced them, there were many challenges with respect to the lack of uniformity. That may ring true for many who are thinking in the crypto space. The lack of clarity and the difficulty of enforcing across state jurisdictions. All too often, hard-earned citizens were parted from their money. In 1933, as part of a broader array of regulation, Congress passed the Securities Exchange Act, introducing uniform definitions for securities under Section 2A1 of the CEA, and including in that definition a catch-all term, investment contracts. For those of you who are amateur lawyers who have spent significant time thinking about what regulation will shape the crypto investment landscape, you're deeply mindful that the term investment contracts was later interpreted by the United States Supreme Court in 1946, describing a test whereby state and federal regulators and courts, state and federal, could appreciate what types of investment arrangements Congress had given the Securities Exchange Commission the authority to oversee. Well, actually, a bit earlier in our national financial markets history storyline, there had been efforts by Congress to empower a regulator to diligently surveil commodities markets to prevent similar fraud and market manipulation. You see, the potential for bad conduct exists in all markets, with no exception. In the late 1700s, U.S. commodities markets participants had formed, informally and formally, exchanges where producers traded eggs, vegetables, grain, corn, wheat, soy, cattle, etc. These exchanges were primarily cash markets. We use the term spot market for these cash markets because often you would purchase on the spot the cattle, the corn, the soybeans, etc. This is the point of origin for the CFTC's authority to regulate commodities markets. But today, the commodities that we regulate span a variety of asset classes. These include not just the agricultural products I described earlier, but energy products, including crude oil or natural gas, precious metals, complex financial contracts, and more. The remit of the CFTC includes a broad range of underlying assets. Similar to and parallel with the definition of a security that I mentioned earlier in the Securities Exchange Act is the definition for commodity in the Commodities Exchange Act. Here in section 1A9, a commodity is described as any physical commodity, agricultural product, wheat, cotton, etc., natural resource, oil, gold, silver, currency or interest rate. And included in this term, this definition for commodity, is another catch-all phrase. So one takeaway from this conversation I hope that you'll have as you move forward is that at any cocktail party, you can adamantly describe the definition of security and commodity under two federal statutes. Following this, in 2010, in the Dodd-Frank Act, Congress included a provision for retail commodity protections. These retail commodity protections are increasingly one of the bridges, if you will, that enable the CFTC to take a careful look into the market for digital assets, cryptocurrencies specifically. Okay, if you're still awake, congratulations. You're on your way to being a certified securities and derivatives lawyer. If you fell asleep for a bit, here's the headline or the recap. I am simply emphasizing the breadth of federal regulators' authority to enable federal regulators to introduce and enforce regulation in the market for any product that may fall within the ambit of our jurisdiction. Admittedly, determining what may be an attribute or a security or a commodity is not an easy task. And for most of you who are well studied in the legal issues that are plaguing the lack of regulatory clarity, or what I would describe as a regulatory gap between securities and commodities regulation as applied to the digital asset universe, you can appreciate this is a challenge. Studies indicate that it may very well be worth coming to a definitive conclusion about which attributes or which characteristics land a financial product that we might describe as a digital asset in either the securities or commodities bucket. I'm going to pitch for just 1 second the notion that regulation might be one might be well served to embrace regulation if you're thoughtful about investing in the digital asset market. Why would I say that? Economists have produced study after study, including studies by Nobel laureates, that establish that orderly, liquid, transparent, competitive markets reduce the cost of raising capital, reduce transaction costs, increase the likelihood that there will be smoothing of frictions in markets, increase the likelihood that we will be successful in surveilling and identifying fraud or manipulation in market, and offer clarifying power with respect to minute details in financial market transactions, including what qualifies as collateral, how do we value the collateral to a contract, how might you resolve conflicts with respect to the default of a counterparty who fails to deliver his or her obligations under a contract. Yes, it may seem counterintuitive, but even the most ardent supporter of cryptocurrency markets may have good reason to welcome regulatory clarity and compliance with regulatory obligations. All right, so if I didn't lose you in the survey of the law, hopefully I shocked you awake by encouraging you to want to embrace regulation. Eat your vitamin, take your vitamins, eat your vegetables. That's the takeaway there. Both have been associated with healthier lifestyles for individuals and markets, right? So here we are, and we arrive at a moment where we could think carefully about exactly what digital asset markets look like. We could start in 2008 with an unidentified person or group of people who use the pseudonym Satoshi Nakamoto and publish a white paper innocently titled Bitcoin, Peer-to-Peer Electronic Cash System, outlining a decentralized peer-to-peer system for making and processing payments. We find with the introduction of this very innocuous idea or technology, a notion that it could be possible to leverage technology to facilitate the introduction of a variety of benefits for a number of communities. These benefits potentially include, and we can take a step back and just think about the most underlying technology for all of this, which would be the internet. These benefits include radically increasing access to basic resources for many communities. If you doubt that that's possible, I'd proffer a specific example. In Kenya, a company known as Safaricom has adopted or developed a technology known as M-Pesa. M-Pesa is a mechanism whereby one can transfer mobile phone to mobile phone cash payments in the context of any market. So back to those agricultural markets of yesteryear in the United States, thinking forward in the current and contemporary moment to market women in Kenya or Uganda, it could be more than feasible to transfer using a phone only, no bank account required, value from one person to another. We can also imagine any number of other diverse use cases for the broader distributed digital ledger technology that are well beyond digital assets and cryptocurrencies. In fact, a number of businesses are deeply engaged in R&D for the purpose of identifying pathways to use this transparent technology to facilitate the transfer of goods and services across the globe. There is potential also, I would say specifically to this audience, for there to be opportunities to create intergenerational wealth and to engage in entrepreneurial activities that may heretofore for many generations not been available in diverse communities as readily accessible as they might be using distributed digital ledger technology. Here I would pause to point out sort of one of the things I highlighted earlier, this notion of raising capital and the capacity to raise capital. And I would underscore that in a paper that I was working on ahead of the call from the White House, Ahead of the call from the White House. The paper focused exclusively on the challenges of funding Black founders. And the goal of the paper was essentially just to explore historically the access or lack of access for entrepreneurs seeking early stage access to capital. This would be seed capital well ahead of an initial public offering. This would be money largely probably in this context crowdfunded, but hopefully supported by venture capital firms or angel investors, and sort of parsing through the challenges of pattern matching and the difficulty of connecting those investors with the type of resources that ultimately will lead to significant financial success through an initial public offering or another pathway. I offer this example very explicitly because one of the conversations I've had that has been a difficult conversation to fully embrace as a regulator is that the innovative technologies that you all are talking about this yesterday and today over the course of this conference really have the potential to empower entrepreneurs to effectively ensure that they gain access to these opportunities. So specifically, I'm thoughtful about a young Black man I met at a conference within weeks of my having been confirmed. He is hoping to launch an NFT exchange. And his NFT exchange, he hopes, will facilitate artists and creators who desire to retain ownership and rights to everything from music to art, which historically in our community, lack of access to ownership of those rights, those intellectual property rights, has often eliminated a significant stream of wealth. These are all exceptionally exciting possibilities, but I have to balance that with the reality of what I've spent my everyday doing. I would love to have done all the things I've just described, but that's not where I spend my time. I've spent much more of my time enforcing the regulations that require that investors not simply be scammed out of their money. So thoughtfully, I turn now to the enforcement actions we have undertaken in the context of the last several years at the CFTC. First, I'd highlight for you that in the last few years, we've had a significant uptick in a variety of types of fraud. Garden variety fraud persists in all markets at all times. Someone would happily pick your pocket if they saw your iPhone or something else dangling and it looked like a potential treat for them. There are bigger and broader problems, though, in the context of the digital asset market. Some of these concerns have so prompted regulators to engage that the White House itself has called on the CFTC and SEC to continue to rigorously and robustly enforce against violations. I'd highlight here that Secretary Janet Yellen herself pointed out that notwithstanding how exciting technology might be, it's important that regulation should be tech neutral. Great care must be taken and applied to ensure innovations do not cause disparate harm to vulnerable communities or exacerbate social, racial, or economic inequities. In this context, what I'd highlight for you all is that under the CEA, the CFTC has brought more than 50 enforcement actions that relate to digital assets. I'd highlight one specific class of those actions for you all to think about today, and that's affinity-based fraud. So if you're familiar already, you'll note that affinity-based fraud is a scenario in which someone engages in a fraudulent scheme, but they perpetuate that scheme through a network of relationships. All too often that network is a church group, or members of a synagogue, or another affinity-based collection of folks who would trust, at least on first sight, based on credentials and relational connections, the person who's suggesting to them that they undertake a particular investment. Affinity-based fraud dates back, at least in the United States, to Charles Ponzi and the creation of the Ponzi scheme. So this is not anything new under the sun. But the reality is, we are in a scenario with respect to digital assets where the demographic or population of investors is disproportionately in comparison to broader TradFi markets, retail market participants. And what that means is people are learning about and gathering information about digital assets through the communities where they work and live. That creates a really significant concern for us as we try to educate the public about their rights as investors and the concerns they should take into account. If I were to list them all now, we'd be here all day long. I'll highlight just a few because it's really worth pointing out. One, there are no, or all too often, there are no FDIC security net style protections for investors who are investing on platforms that are not
organized and chartered as state banks. In other words, if you place your money into a TradFi intermediary, and that TradFi intermediary is registered as a federal or state bank and a member of the FDIC, it is the case that in the event that the entity itself fails, there are protections for your monies guaranteed by the federal government. This protection does not, in every instance, map onto hot and cold wallets that you might, or investors might choose to use for purposes of investing in digital assets. It's important to get that message out. It's one thing for people to choose to invest knowing that that is the case. It's a very different outcome where people have invested and come to be surprised to learn the terms of the contracts they've invested in. I'll give another very specific example in terms of the savings accounts offered by Celsius Network. Many of you are intimately familiar with the reality that those arrangements were not in fact savings accounts. And ultimately, at the sort of final hour when the business found itself flailing and suffering a liquidity and solvency crisis, it had to be noted that those funds that belonged to individual investors would suddenly become part of what would be used to pay out the creditors of the intermediary that was facilitating transactions. The cash held in accounts was not held in separate accounts. It was not treated as we require registered financial market participants to treat individual assets, and therefore it became the case that those investors were not investors at all. They were general unsecured creditors with very limited rights to recover the money they had invested. This morning at 7 a.m., I received an email from a gentleman who is following up on one of the cases that we recently prosecuted that involved digital assets. He has asked me 3 questions, and he's asked them at least on 2 different platforms, social media platforms. How do I get my money back? Can you help me get my money back? This is an exceptionally difficult email to receive as a regulator because by the time that this kind of issue comes to us, there may be limited capacity for us to intervene. I'll close by sharing just a few reflections. I could go further, right? Cybersecurity risks, cross-chain, interoperability concerns. I could go much further, but I think you guys get the gist of it. We've not organized crypto markets in a way that gives us the immediate protections that most people have come to trust and believe are part of our engagement in financial products. I want to close with just offering a bit of a light at the end of the tunnel, a bit of hope, if you will, and that's our progress on a path toward adopting legislation and regulation. So at the beginning of the year, President Biden issued an executive order and asked that all financial market regulators produce reports that would describe exactly how we could go about framing regulation for the digital asset ecosystem. Following the executive order issued by President Biden in March, later in August and September, the Treasury Department and FSOC, the Financial Stability Oversight Council, each issued reports in compliance with the executive order. At the same time and over various points in the last few years, members of Congress, the House and the Senate, have introduced a number of bills attempting to offer a pathway to regulation. Most recently, news cycles have been dominated by 2 specific bills. One, Responsible Financial Innovation Act, proposed by Senators Lummis and Gillibrand. A second act, the Digital Commodities Consumer Protection Act, proposed by or introduced by Chairwoman of the Senate Ag Committee, Debbie Stabenow, and Ranking Member Bozeman. The latter bill has gotten a tremendous amount of attention because it really sort of circumscribes focus for a limited portion of the market, whereas the earlier bill that I referenced, the bipartisan bill by Senators Lummis and Gillibrand, is a very comprehensive bill describing a significant number of interventions across financial markets. In the current moment, what I would suggest is I'd like to highlight just one provision from that DCCPA that came out of the Senate Ag Committee, and that's Section 7, if I recall correctly, a provision advocated for by Senator Cory Booker. That provision requires or solicits a study on the impact for marginalized communities investing in cryptocurrency. And this is largely to ensure that financial inclusion and access are just that. Inclusion and access that lead to positive pathways, inclusion and access that lead to the development of that intergenerational wealth described earlier, rather than pathways that might simply leave people worse off than they were before. So I applaud Senator Booker for including this provision, and I actually want to just close by offering 2 or 3 steps I want to take during my time as a commissioner that I'm hopeful that you will help me with. The first is I'm advocating for inclusion of a reparations provision in the DCCPA. The reparations provision for the CFTC essentially enables the CFTC to bring enforcement actions even if an entity is not registered as a registrant of the CFTC. This is important because I referenced to you the email earlier that I received. One of the limitations in the current moment in that regulatory gap that I described is that we are limited in our ability to go after actors who are not registered as part of our market. It's important for our ability to protect every investor, each type, no matter the qualifications or capital structure or capabilities. It's imperative that we are able to protect all investors. To that end, creating or adding the reparations provision that exists in the CEA and the DCCPA would give us greater power, authority, and resources to ensure that we can effectively police markets. The second thing I want to advocate to our chair with respect to is creating a work stream that focuses on digital assets and their impact on diverse communities. There is already a CFTC Digital Assets Task Force. The task force is broadly focused on developing regulation for the entire market, and I think that's very important. But when I describe vulnerable communities, I mean communities of color, low-income communities, but I'm also referring to veterans and active duty military. I'm also deeply thoughtful about rural populations that might have less access to early education, on investing in diverse asset classes, specifically digital assets. So my notion of vulnerable communities actually is quite broad, and my hope is that the CFTC can organize regulation to fit this category. Finally, I'd like to be an ambassador, and this is the piece where I really desire you to help partner with me if you're open to it. I'd like to be an ambassador that brings together the academic community, industry participants, and regulators for the purpose of having a robust, fulsome conversation about what regulation ought to look like and why. I'm thoughtful that there are sophisticated and diverse investors. There are sophisticated investors in the diverse investors population that have capital to burn. And we want them to have the opportunity to take the kinds of risks commensurate with their ability in markets. But we also want to balance that with the needs of those who might have limited disposable income or limited access for investing. I've also been chided to consider that every person wants the opportunity to invest. Every person wants the opportunity to grow the wealth that they have in their pocketbook or portfolio. And if that is to be true, we have to think really carefully about what the guardrails ought to be for this industry. So I'm deeply grateful that you are here. I'm hopeful that your presence here and our ability to connect here is the beginning of a conversation and a relationship that will continue for the entirety of the time that I'm in service and then even beyond when I'm back in academia. Thank you so very much, Dr. Imdad, for the invitation to join you. Thank you, Sanjay, for the wonderful introduction. I look forward to today's conversations, and I look forward to meeting so many of you. Thanks so much.
Thank you so much, Commissioner, for a wonderful speech. With regards to the last part of your speech that you talked about, the suggestion of going after unregistered entities with CFTC, how do you see that in terms of the CFTC jurisdiction, meaning that would that require reporting of unregistered entities also to the CFTC ahead of time, or you're just talking about the prosecuting them after there's a violation, and to provide some sort of security to the investors? Because that kind of like is a tricky question, right? So what would be the oversight? What would be the monitoring part of the CFTC over the unregistered entities? And would that mean at the end of the day that everybody is now obliged to be registered, because that's more beneficial to everybody with regards to the reporting requirement and preventive actions, that actually CFTC can be more cooperative with those who are unregistered to help the entities as well, like the end side of like the business, to help them be, compliant with the law, actually.
This is great, and actually a wonderfully complex question. The first part of, I'm actually going to take the last part of this first, and just signal that, you know, one of the things that is probably very difficult for this ecosystem to fully embrace is that the remit for financial market regulators is broad. That's the reason I offered the lengthy description of the definitions and the statutes. It's broad because there could be many ways that people could be enticed or allured or lured into participating in an investment arrangement that may or may not be to their benefit. And so casting the net broad really creates the potential that those who would charge form over substance and suggest, I didn't create a stock, I didn't develop a derivatives contract, therefore I should not be regulated, that form over substance really leaves the public fairly exposed. And so our goal is not to require every kind of business to register, but to require businesses engaged in products that fit within our market to register. There are challenges, however, in the immediate moment. This is such a rich illustration regarding businesses even knowing if they are the type of business that ought to be registered with the CFTC. And then there are great questions like, well, why would I register with one financial market regulator and not the other? And then somebody and somewhere might say, register with both. But this is an expensive process, it's an arduous process, admittedly. And so for businesses who are considering this, it's no small feat. And then once within the regulatory framework and umbrella, if you've registered, then we presume you could only successfully register if you actually create or develop or launch or distribute a product that fits in our markets, right? If that is all true, being under the umbrella of registration is actually very beneficial for a number of reasons. There's a continued dialogue between the regulator and the regulated entities. And that dialogue can begin with just asking the question, what would we have to do to be in compliance? And I think often when market participants come and their questions are that sincere and genuine, we want to not be out of compliance, what do we have to do? There are professionals at the CFTC prepared in the Office of Technology and Innovation in the context of the CFTC's hub that we've created for purposes of facilitating these conversations, Lab CFTC. We have really thought carefully about how we can have conversations with entities that want to come into our markets. I'm going to give you a specific example as to where many trigger the fault line, if you will, for having failed to register, and often where enforcement actions begin. They begin with onboarding. Soliciting customers to participate in an endeavor can be a big task and responsibility, but one of the obligations that we require across financial market regulation is if you take money from someone, you have to verify the identity of the person whose money you're taking and the source of the funds. And this is largely to prevent much broader and more significant concerns. National security concerns related to funds that might be used for terrorist activities, anti-money laundering to protect the integrity of our markets. And these basic premises for many businesses that are unfamiliar can be surprising that this is an obligation, and why would this be an obligation? And then there are those on the distributed digital ledger side that say, oh, we have a fix for that. We can verify identity through the blockchain. All acceptable conversations, but important conversations to have to ensure the overall integrity of markets. So I think your first point is right in that we want to get that dialogue going. We want to ensure that those who should be under the umbrella of financial markets regulation are there with knowledge that they are meant to be overseen and have good guidance about what it means to be overseen. And to be quite honest with you, for many, many decades, this had not nearly been such a significant question because of intermediation in markets. We remove intermediation in this new ecosystem and offer direct to customer services. Those direct to customer services create obligations for whomever is offering that service that are different than what might have been in the conventional structure, the TradFi structure. In the TradFi structure, the intermediary did all that work. I need a copy of your license, I need a copy of your social security card, or whatever other identifying information and documentation would have been aggregated and collected. Now that the entrepreneur might take that on, and there might be algorithms for this or other innovative interventions that can facilitate this, but that responsibility will rest with the person who launches the endeavor. And it might be a great idea to get good advice and counsel about whether it triggers an obligation to be registered or not. The reparations language, though, to be really thoughtful, grows out of a panoply of different interventions that we've adopted over the years. One of them is the red list. We publish a red list periodically that essentially describes all the businesses we know who are out fishing or using other technologies to entice folks into romance-based cryptocurrency purchasing platforms or any other sort of quite curious approach to get people to give their money or bank account or other information over, right? So when we're familiar with that kind of thing is happening, we publish a list of the kind of the platforms that are engaged in that kind of activity. We also acknowledge that these platforms may not be within our remit, meaning let's say they're not an entity we could enforce or prosecute against. They may be organized overseas, operating fully overseas. It may also be the case that they're not registered with us, and so we're signaling that if you're giving them they are signaling to you on their website, they are CFTC registered. But we are publishing a list to disclaim that. In fact, they are not CFTC registered. So those steps, along with investment advisories, have been our biggest consumer education endeavors to date, but they may not be enough. And I would love to hear from you all if there are other ways that we should be engaging in intervention that we have not yet engaged in intervention. Thank you.
Ms. Johnson, my name is Oleiko Denner, and I'm the founder of Black Women Blockchain Council. I also have experience as a chief compliance officer. I served for over 10 years. And so my question is really to the DCCPA. I know you mentioned that Cory Booker, his concern is the consumer, minority consumers. But my concern is also the fact that minorities aren't just consumers, they're also builders, right? So with the DCCPA, the requirement to now register under the CFTC, the cost of operation is typically for institutions, right? So are you concerned, or are you guys aware that that operational cost could actually create barriers to limit consumers to now be builders or participate in areas different from consumership?
This is a great question, and I think it really goes to this point that I was raising earlier about the balancing. And it's a balance that relates to, thank you so much for pointing out, not just participation as an investor in the market, but participation as a developer, as a service provider in the market. What I would signal is this is exactly the conversation I'm hoping to have, largely because as we begin to parse through proposed language in the statute, many questions are popping up. For those who are familiar, there are questions emerging regarding how we distinguish between CFI and DeFi, or centralized finance and decentralized finance in the context of the language of the bill. There are many questions regarding how to best understand and define a digital commodity trading platform. These are kinds of terms, if we lifted out, as I said before, the structure or the framework of the statute that governs securities or governs commodities. These are very common terms that have historically been used, but one of the really big challenges is in a universe where the market structure is disintermediated, how do we actually capture how do we insure against the things we want to protect consumers and markets from, at the same time offering innovation a chance to flourish. And this question about disparate costs or disparate impact of costs for developers could be a really great one for us to begin to take into account and consideration. I suspect that would likely come into play in the regulation even more than the legislation, which is why I'm really here, a voice crying in the wilderness. It's time that we start to think about what the regulation might look like, because even if the legislation, when it comes, is reasonably effective and a middle ground that satisfies those who are seeking a statutory fix, the regulation is really where the rubber meets the road. And there is the space where there could be a conversation. That's why I'm calling for the chair to really begin to think about it now. A conversation about structuring tiers regarding who's participating and what their participation is in the market and what the costs of registration are related to that. We haven't historically had nearly as much of that because markets were intermediated, and the intermediaries have been sophisticated financial market participants or financial institutions that are very often the subsidiary of a parent company that is a registered bank holding company, or another entity that's already deeply engaged in the regulatory architecture of financial markets. Trying to think about